Hello friends, welcome to Pen and Paper channel. In today's session, we will understand the difference between filing a check bounce case under section 138 of the Negotiable Instrument Act 1881 and filing a civil recovery suit under civil law. This video will be especially helpful if you are a complainant and want to choose the best option to proceed for your recovery. So first we will see the check bounce case under section 138, that is criminal recovery. So friends, a check bounce case is filed under section 138 of the Negotiable Instrument Act 1881, and this is a criminal offense, and the punishment for this is imprisonment up to 2 years or a fine up to double the check amount or both. Since it's a criminal in nature, it creates the strong pressure on the accused who is going to fear the jail or which is going to have a heavy fine. So friends, now we will see the criteria for filing under section 138 of Negotiable Instrument Act. To successfully file a check bounce case under section 138, below are the criteria or the conditions which need to be met. So the first one is the check need to be presented within 3 months of its date. For example, a check is given to you and there is a date for which the check is going to be valid, and from that date if you just see below, it has also been mentioned that it is going to valid for 3 months. The second criteria will be it must be returned unpaid by the bank, for which you will also going to get the return memo. So this is the second criteria. Then once you are going to receive the return memo, you need to send a legal notice within 30 days of the dishonor of the check. After that, you need to wait for 15 days and the drawer must fail to pay within 15 days of your receiving the notice. And in case if he is going to pay, then we won't be proceeding the matter further. If in case the payment has not been done, then definitely you need to file a complaint within 1 month under section 138 of the Negotiable Instrument Act. If in case these all criteria have been met, then definitely the case is valid under section 138. And if in case if you miss any of the steps, then the complaint under section 138 is going to be fail, and then your option is going to be only file a civil suit recovery. Friends, now we will see the civil recovery suit. So friends, a civil recovery suit is filed in a civil court. This is going to become under Order 37 of the Civil Procedure Code 1908, and its purpose is only to recover the money under this section, and the process is the time consuming as compared to the check bounce case, and since this is in civil nature, so definitely it is going to be time consuming. And the most important, the accused is going to enjoy more liberty here, and there is no threat of the imprisonment. So basically, whenever there is no criminal punishment, then the accused will be having enjoying more liberty. So that's the reason this gives a lot of flexibility to the persons under uh, when you are going to file under Order 37 of the Civil Procedure Code. Friends, now we will see the main differences between the both of these sections. One is the criminal offense and other is the civil offense. Whenever you are going to file the check bounce case under NI Act, so this is going to be the criminal in nature, where there is the accused is going to have some pressure, so that he is going to have some fine and the uh, imprisonment. And in this civil recovery case, as the term mentions, civil procedure code, so this is a civil suit, then definitely there is no that is the pressure on the accused. This is the first main difference. And the key difference is that section 138, which is a criminal and which is going to create a fear of jail and fine in the accused, but you must strictly follow the filing criteria what we have discussed before, or else the case may fail. And Also, in the civil recovery suit, under Civil Procedure Code is slower but does not depend on such strict timelines. So that's the reason the enforceability from the law is different here. And here also, as per the criminal nature and the fine and imprisonment, so this makes the accused very much fear, and recovery is like you are going to get the recovery as well as the compensation for the time which they are not going to pay you. So friends, now we will be discussing which option is better for recovery. And if you want a quick pressure, so section 138 under an act is more effective because it creates fear of jail and fine. So you need to be more careful while you are going to file, and you need to meet all the criteria here. And if your main aim is to just recovery of money, then civil suit is also fine. And the important, even if your section 138 case fails, the criteria were not followed, you can still proceed with the civil, that is the recovery suit, and it may be time consuming. So it is going to ensure your right to recover money and not lost. But even though there is a some timeline for which there will be some time consuming process in civil procedure, but again, your right is going to be covered. Friends, since now we came to the closure of this video, in summary, check bounce case under Section 138 of the Negotiable Instrument Act are criminal in nature, which is going to create strong pressure on the accused, but they require strict compliance with the timelines. In other words, if you go for the civil recovery suit under Order 37 of the Civil Procedure Code, which is slower, but they remain open as backup remedy if in case Section 138 is going to fail due to any of the reasons. So, not to worry about that, you need to file under Order 37, that is CPC. If you are a complainant, follow the correct criteria under Section 138 to strengthen your case, and use civil recovery as a safeguard if needed. If in case anything the accused or the defense lawyer is going to come up during the trial, then definitely you have the civil recovery, in other words. So this video is explained to you by pen and paper. If you found this video helpful, don't forget to like, share and subscribe for more simple legal explanations. Thank you.